All right, you locate the passage then. And meanwhile, I'll just summarize because there's nothing much in this passage. It's just legally it makes some sense. Otherwise, the passage doesn't have much of a concept in it. Basically, a student-friendly legislation has been promulgated by the Rajasthan government, and the social evil that it seeks to curb is the ongoing spate of student suicides, and moved by the plight of students, the stress under stressful conditions in which they work. The government has come up with this bill, wherein they have stipulated certain norms for hitherto unregulated industry, and the norms include things such as having proper teachers, paying due attention to student health, having student counselors, and then meeting proper space requirements for students to sit and study. And there are a plethora of recommendations, and then also recommendations in the making of the requirement for registrations and prohibiting certain kinds of advertisements which give false promises to students, making outlandish claims like 90% success, 80% success, 70% success. Such claims which mislead the students into opting for something to which they are temperamentally or academically not suited, and giving them false hopes and false dreams. So this basically talks about all these aspects. Now let us quickly go through the questions one after the other. Question 112. Ajay runs a coaching center in Jaipur that offers preparation courses for competitive examinations. The center charges fees which is twice that charged by such institutions. Then the center also has a lack of adequate facilities and proper teaching methods. Under which provisions of the Rajasthan Coaching Centers Control and Regulation Bill can Ajay be held liable? Now, the thing to be noted here is that charges fees which is twice that charged by other institution, that brings it within the coils of commercialization. There may be allegation of commercialization. Then center also has lack of adequate facilities. This can bring in the lack of registration also, because at the time of registration they have to declare certain facilities, and they might not have declared those facilities. So it is also possible that the registration may not have been done, because had the registration been done, and then they would have all those facilities, or they can even falsely show those facilities when actually they don't have, and the bill does not seem. Does the bill have provisions for inspections also? If the bill will have provisions for inspection, then the registration will not come about. So the registration aspect may be included in it. And then there is, of course, lack of adequate facilities, which will bring in the non-registration and then failure to maintain adequate infrastructure. So first, second, and fifth will be there. First, second, and fifth will be the correct option, as has been rightly done by one of the critics. Is that okay? Sure. Can I move forward? So Ramesh operates a chain of coaching centers in multiple districts of Rajasthan. They keep a large number of staff deployed who have a reputation for hard work and results. The centers have high quality infrastructure. They claim success rate of 90%. Now this is an exaggerated claim. In competitive, this goes against common sense that somebody can have a 90% success claim. That does not exist. That is not there. This is a misleading claim, making extravagant claims, right, of the performance. The choices B and C are really very close. Misleading claims about teaching excellence. This is making extravagant. They are not saying that in what is implied here is, of course, that the students score 90%. The students are in 90% this thing. This is what they are saying, right? So impliedly, you can say this is teaching excellence also. Then Prakash runs a coaching center in Bikaner, specializing in preparatory courses. His center was accused of misleading advertisement, charging exorbitant fees without providing adequate facilities. Fire incident in which a part of the premises of the chief secretary. Now, this is a coaching center in Bikaner. Bikaner is district, as is popularly known. And the chief secretary doesn't have the powers to chair such a meeting and pass an order. Who has the powers? Who has the powers? District magistrate. This is what you have to see in this. Who has the powers and who has passed the order? It is the district magistrate who has the power. Once the district magistrate has the power, and the chief secretary can't usurp his powers. That is not allowed in law. Now, where is it given in the passage? Can you see in the passage as to where this is specified? This is the legally pertinent information as to who has been entrusted with the power under the Act. And since it is the district magistrate who has been entrusted with the powers under the Act with his boss, the chief secretary cannot exercise those powers, right? Should I point it out, or is I think that is, yes, it is, I think, passage number. If you see, if you have a look at first, second, third, fourth, fifth, and sixth passage from the top. As a part of the law, a Rajasthan Coaching Center Control Authority will be constituted at the state and district level, right? The state's higher education secretary will be ex officio chairman of the district level authority. The authority will have the mandate to enforce the regulations under the law and penalize the offenders, right? So district collector will be the chairman at the district authority, and this is happening in the district of Bikaner. Therefore, you can't say that the order passed by ex officio chairman, the secretary of higher education, will be a valid order because he doesn't have the power under the law. The law has reserved those powers for the district magistrate. Then the district magistrate has to actually use those powers, and not the district collector, right? Then next question, I come to 115. A coaching institution makes multiple violations of statutory norms. As a result, it is visited with a penalty of rupees 10 lakhs. Now, how much is the penalty specified under the rules? This is where the problem is in this paragraph. The penalty specified is 10 lakhs. Here the penalty they say this is 10 lakhs. And how much is the penalty specified under the rules? Can you show me where is the penalty specified under the rules? The 10 lakhs penalty which has been imposed is extravagant and not authorized by law. Therefore, that is liable for being struck down, right? Then you have, I go to the next question. Wait for a second till it moves. The cursor starts moving. That is the systemic limitation. We can't help it. Now this is 116. At parent request, a coaching center in Jaisalmer begins offering an early preparatory program for competitive examinations starting from grade 6. Now, the students are given instructions in general knowledge, including mathematics, science, and English, current affairs. After the course commences, it quickly gains traction with parents, and they turn out in large numbers, buoyed by teaching quality and student performance. Tahsildar makes a survey and raises an objection against the classes. Has the coaching committed any illegality? There is no illegality because here you will notice that in the passage they have removed the age limit. Means children in 6th class, in 7th class, in 4th class, in 4th class, in 8th class, 7th class, any age child can go and sit in the coaching. That is what. Earlier they had the limit of 16 years. They toned it down. What could probably be a reason that they toned it down? One of the reasons could be that these coaching institutes have a lot of financial muscle. So they could persuade the central government, the state government, to liberalize this because this challenges their business model, and therefore, and the government takes a lot of money from these institutions as a part of their expenses. I mean, by way of uh, by way of charity, you can say, or by way of donations. This could probably one of the reasons lobbying. The government gave in to lobbying. However, the bill has conspicuously removed 16 age criteria. Now, this was removed by the Ministry of Education. Now, this was removed. It means what? That means you can see the power of the coaching institutes. You know, first government makes a puts an enactment, and then the government under popular pressure from lobbying pressure from the coaching institutes knows that. So, and the Tehsildar was actually acting on the basis of the prior law, and he was not updated on the law probably. That is why he made a survey, and in the survey he raised this kind of objection. He is authorized to make the survey, but he is not authorized to make this kind of objection because this is not authorized by law. Right? Go to the next question. 17, 18, 19. Then there is a new question.
So this passage is about a case that happened over 40 years ago, where a minor girl was raped. So in this passage, the Supreme Court said that a small girl's silence and tears during the court case, they can't be taken as a sign that the man accused of raping her is innocent. And in this case, the man who was found guilty in 1987, but later the High Court let him go free just because they assumed that they said that girl didn't speak during the trial and just cried. And the Supreme Court said that this was wrong because a child can be too scared or hurt to speak, and we can't expect a child to explain everything. And other strong proof like medical reports and other proof showed that the man was guilty. And now the twist is that the man who committed the crime in his youth will now serve his sentence in old age. He is over 60. And finally, the justice arrived. But it can be seen as a bus stuck in traffic for 40 years. And after all, it returned. Now he will serve in jail again.
Remaining part of sentence.
So isn't it like justice provided late is justice denied?
That
I
is why
mean,
there is
I have heard this term multiple times.
justice delayed, justice denied. That,
Yes, sir. Exactly.
but you see the trauma of the person also, on whose head the sword hangs for 40 years. Just imagine, so one day my fate will be decided. So, of course, there is a grain of truth in justice delayed, justice denied. You know, you're right. But then you require more and more young people into the judiciary. But then the problem is not of young people these days. The problem is young people are deciding very fast in the district judiciary. But in the high courts, when matters of all the districts where they converge, and in the Supreme Court, when matters of all the states and union territories represented by 25 high courts through the length and breadth of the country, when they converge before a single Supreme Court, then then there is a backlog of cases. Now there is a talk that they will have a Supreme Court bench at Mumbai also. Anyway, this is not final. But then the only way out is that you have to increase the number of judges. What else? And you have to prune the procedures also, wherein adjournments cannot be granted lightly. But then the High Court will have to significantly increase the number of judges, and in the Supreme Court also. Yes, Tanishka. That's why you people have a very bright future. That's why I say become judges. High Court and Supreme Court birth is there for you. But these are constitutional positions which will take you much higher above the bureaucracy in terms of in terms of protocol, in terms of your emoluments, official perks, in terms of recognition in the society. Constitutional post is a very high post of the High Court. The authority of High Court is very, very high. And the Supreme Court, what to say? Yes.
This passage talks discuss about the 40-year-old rape case in Rajasthan, where Supreme Court reversed the acquittal of accused in Chhatra who has been convicted by trial court in 1987 for raping a minor. Accused of Chhatra was convicted and sentenced to 7-year imprisonment in 1987 by trial court but later acquitted by the Rajasthan High Court in a 6-page judgment after 26 years. And Supreme Court criticized the High Court for acquitting the accused based on survivor silence during cross-examinations, stating that the child trauma and induced silent tears cannot be acquitted to innocence. The medical and circumstantial evidence pointed to the guilt of accused, leading Supreme Court to reverse the High Court acquittal and uphold the trial court to conviction and sentence. High Court took 26 years to decide the appeal, and Supreme Court ruled on the Rajasthan government
Yes.
appeal after 2 years, highlighting the extensive delay in constitutional court. And the accused, now over 60-year-old, has been ordered to surrender within 4 weeks to serve his sentence.
What did you say? The last one I didn't catch because there was a breaking of voice.
The accused, now
All right.
over 60-year-old, has
Yes.
been ordered to surrender within the 4 weeks. And importance of sensitivity in handling assault cases, the need to for faster judicial process.
Yes, this Justice Krishna used to say that you need just a couple of sensitized judges to do justice, and you don't really need. There's nothing wrong with the law. There's everything wrong with the judges because unless you have properly sensitized and uh, properly what we call as empathetic judges, you can't get justice. So people who are sensitized and empathized, who are capable of empathy. Empathy means fellow feeling. Those compassionate people, those people actually should come into the judiciary, and not those people who are actually sitting with all kinds of biases in their heads, already prejudged, very orthodox. Not those kind of. Yes, yes, Raya. What do you have to say?
So this article is about a case about the man called Chatra who had been convicted and sentenced to 7 years for the sexual assault of a minor girl in Rajasthan. So what happened was during his trial in the Rajasthan High Court in 2013, the High Court had cited the child victim's silence during the cross-examination as a lack of evidence and had to release him. However, the Supreme Court had condemned this reasoning, asserting that a child victim's trauma-induced silence cannot be equivalent to a adult silence and should not benefit the accused. It had criticized the High Court for its misjudgment and
Yes,
delaying the appeal for nearly 6 years. He
yes,
then highlighted that the medical and circumstantial evidence had confirmed the rape and restored the trial court's conviction and sentenced the accused to 7 years.
yes. So this case is exemplifies the rule of evidence, how you assess evidence. The trial court had the victim in front of them. High Court did not have the victim in front of them because the evidence is not led in the High Court. Evidence is led in the trial court. So the trial court had the victim before them. Unfortunately, in our country, uh, evidence is not taken in under camera as of now. Camera evidence is not there. In the United States, the evidence is recorded under camera, so it helps in the sense that sometimes the you need to visit the face of the victim in order to see the expression. Otherwise, you just have a written record. You can't see the expression. On the basis of sometimes expressions tell so much about the face of an individual, about what is transpiring in the minds of the individual. So sometimes facial expressions are very, very relevant. A person may be deposing absolutely falsely and he may be making absolutely correct statements, but something else is going on. The puzzled look on his face can lead a judge to surmise or make an intelligent guess that probably the victim, probably the testator was lying, and so he can prevent the miscarriage of justice. This is one such case. Here the question is put to the small girl, and the trial has been disposed of very quickly in the trial court. Therefore, the girl was still small, still a minor girl, and she was victim of assault. And she just broke down under the trauma, under the pressure of the lawyers and all that. So she just could not stand that kind of scrutiny, and she started crying. From this, the High Court, in a very perverted kind of way, came to a conclusion that the victim did not testify to the case before the court, acquitted the accused on this basis. But there are other pieces of evidence also, like there is a medical examination report, then there is maybe there may be the DNA examination. I mean the medical examination the same. Then there may be other pieces of evidence, the statements of other statements of other people, other witnesses. There may be eyewitnesses. There may have been all this. Though in such a case, the eyewitness likelihood of an eyewitness is very faint. So taking into consideration the totality of the facts and circumstances, the court ought not to have acquitted the accused. This is the entire thrust of the case decided by the Supreme Court, and that you have to take into consideration the surrounding circumstances also in arriving at a judicial, in entering a judicial verdict. You have to be aware of the circumstances in which the victim was deposed before the court, and due allowance should have been given to the tender age of the victim witness, right? So these are basically now these principles will be applied across different situations. There may be a case in which there may be a case of corporate criminality, and then another thing that the High Court probably did was reveal the identity of the victim also. I think is this that case or the subsequent one is there. In 2018, a case was filed against the warden of a hostel for allegedly embezzling funds meant for improvement of hostel facilities. Several witnesses, including hostel residents, provided testimony on the key witnesses V, who had lived in the hostel during the period of alleged misconduct, submitted detailed statements supporting the prosecution case. We described the lack of improvement in the hostel infrastructure despite availability of funds for repairs and upgrades. During the trial, the defense attempted to discredit V's testimony by alleging bias and pressuring V during cross-examination. The defense argued that the lack of direct documentation linking the funds to the warden's personal account weakened the case. Decide whether V's testimony, along with other evidence, was sufficient to convict the accused. Now, what are the pieces of evidence and what is the legal principle that we have just now seen? The legal principle is that you may not be able to come forth with the what the court expects of you, but if there are surrounding circumstances and there are no other, you have not made contrary statements, then still a verdict can be entered into your favor. This is the thrust of of the passage, the legal article, the legal proposition that is thrown up by our reading of the passage of the assault, of the minor's assault. One of the key witnesses who had lived in the hostel during the period V submitted detailed statements supporting prosecution case. We described the lack of improvement in hostel infrastructure despite allocation of funds. During the trial, we attempted to discredit. Now, these are the key witnesses. So, detailed statement has been given before the court, and we has also brought out the fact that allocation of funds was there, but corresponding improvement in hostel infrastructure is not seen. So, during the trial, the defense attempted to discredit V's testimony by alleging bias and pressuring V during cross-examination. Defense argued that lack of direct documentation linking funds to warden's personal accounts weakened the case. decide whether V's testimony along with other evidence was sufficient to convict. Yes, if you look at the principle laid down by the court, that you should take into consideration the totality of the circumstances and not latch on only one piece of evidence against the complainant and then acquit the accused. That is not the right kind of strategy. That is not the right kind of approach. This is what the Supreme Court has explained in the above case. And if you take that into consideration, he has lived in the hostel. He did not. He said that there was a allocation of funds, but the corresponding improvement in the hostel infrastructure is not seen. And then there was pressuring and all that, and even allegations that lack of direct documentation on that. And now there is a case which is there and which the accused has to meet. Therefore, the correct choice will be consistent testimony supported final decision. The testimony is consistent because despite the pressure, he did not whittle down under the pressure and maintained his stand. It is not stated that he took contradictory stands. He maintained the stand, and this was what was his stand. Despite pressure and all that, he maintained his stand. Therefore, the correct stand is this. Now, if this is 100% correct, so I need not take it up. In the case against Rajesh, the treasurer accused of misappropriating funds, Priya hesitated during cross-examination but remained consistent. Now, consistency is a very big thing in courts. If you make contradictory statements, you end up losing your case, or you end up diluting your case by contradictory statements. Priya has remained consistent with her earlier statements about financial irregularities. How should the court evaluate Priya's silence? So, if she has remained consistent, even if she showed some hesitation during cross-examination, the court will go ahead and look at other corroborative evidence and return a verdict of guilty. This is what is coming from the reading of the passage also, that if there is some slight irregularity somewhere in the trial proceedings, you can't really capitalize on it and ignore everything else. That is what is the upshot of the case we have read. But there is another one: a whistleblower exposed corruption. Trial court convicted the accused officials and sentenced them to imprisonment. On appeal in 2013, Rajasthan High Court acquitted the officials, citing inconsistencies in the whistleblower's testimony, whose identification was also provided in the judgment. Now, this is this Whistleblowers Act. Now, this is a matter of, you will tell me that why did you say that privacy has been violated when it is not given in the fact situation? Now, you see, whistleblower is a matter of general knowledge. Whistleblower is a person who actually blows the lid off some scam. That is a whistleblower. And there is a Whistleblowers Act which ensures that the identity of such people will be protected. And it is provided for because whistleblowers, just like RTI activists, are under a threat that the accused might inflict harm on the whistleblower, right? So this is a matter of common judgment. Now here is a case, this is a matter of common knowledge. Here is a case where whistleblower's identity has been leaked by the court in the judgment itself. Now court itself has gone wrong, right? So when the court has gone wrong, then in that case the whistleblower is entitled for due compensation or some other recompense. Trial court convicted accused officials. On appeal, the Rajasthan High Court acquitted, citing inconsistencies. So this will be overturning the High Court's acquittal, because the whistleblowers also are under quite pressure. They have to conceal their identity, because not concealing their identity can expose them to serious prejudice, right? So they are under quite pressure, and the court can take note of such pressure, right? Then you have 124. In 1995, an NGO worker reported illegal deforestation activities conducted by a company. This is a worker who is pitched against company's executives. The trial court convicted the company's executives based on photographic evidence and testimony. So there is circumstantial evidence, there is corroboratory evidence. However, High Court later acquitted the accused, stating that NGO workers' hesitation. Now, there is the same question exactly as the fact situation, only the context is different, but the principle remains the same, except that there it was an assault case, here it is a corruption case, right? This is a case of an illegality, that is a case of violation of bodily rights and bodily autonomy, right? So this is hesitation will not be given due importance, and the other pieces of evidence will not be ignored merely because there is an the the complainant hesitates and is not able to depose properly, right? Uh, the then there is 19 legal reasoning. The state government announced a project to construct a highway. I think all questions are correct. Six, no, all questions are not correct. All right, tell me, what is this passage about? This passage is about simple questions, but the passage has important question of eminent domain, which is also a current affairs legal item, legal current affairs item. So quickly read the passage and tell me.
There is a case involved a 33-acre near Narela Bhavna Road acquired for Delhi Agriculture Marketing Board in 1963,
Yes.
with compensations determined in 1986. A woman claimed ownership over the portion of the land, and the board chairman secretly entered a private agreement with her written half the land allow compensation for other half. And Delhi High Court allowed arbitrations, and the appointed arbiter ruled in favor of the woman, which was later quashed by the Supreme Court, and declared private land return invalid as a public acquisition cannot be undone by the beneficiary, and deemed the agreement fraudulent,
Yes.
emphasizing that sovereign land acquisitions cannot be reversed through devious transactions. And once land is acquired by
Yes.
the government, it cannot be transferred through private agreement. Only the government has authority to withdraw the acquisition. And the ruling aimed to prevent delay in the infrastructure project due to post-acquisition litigations and reforms the government authority over public land.
Yes. Next.
In this passage, the Supreme Court said that when the government takes land for public use, no one, not even a public body, can give it away through a private deal, and only the government has power to cancel the land acquisition. And this
Yes.
ruling came from a case where land was acquired in 1963 near Narela Bhavana Road to build a grain market, and later a woman claimed part of the land, and the chairman of the Delhi Agricultural Marketing Board, he made a private deal with her and gave her the part of the land, and claim the money for rest of the land. And the Supreme Court in this case said that the deal was wrong, and called it a fraud. And Supreme Court said that the board had no the agricultural marketing board had no right to reverse the government's decisions. And the court also criticized the High Court for allowing the women's case and cancelling the land acquisition through arbitration. And the court questioned the High Court's decision and said that such actions delay public projects, uh, especially national highways project, and it can't be allowed. That's all from
Yes.
my side.
So in this paragraph, the Supreme Court has ruled that if the government acquires a land for public use, then third parties cannot uh, reverse the acquisition. Now, this decision is in adjacent addressed the issue that when government buys land, there are many post-acquisition litigations that delay many public projects, such as national highways and other stuff. Now, this ruling came after the Delhi Agricultural Marketing Board had tried to reverse the land acquisition through a private agreement to an individual, which the court had deemed invalid, emphasizing that the such a decision would undermine the sovereign power that the state has.
The case basically highlights the doctrine of eminent domain and the reach of the doctrine. The eminent domain means the government may, for a public purpose, take a land, take a private land, acquire a private land, paying the reasonable price for the same. That is the eminent domain doctrine. For a public purpose, private land may be acquired. Now, before the acquisition takes place, any kind of transaction might be entered into by the parties, and that cannot scuttle or wish away the government's exercise of power under the doctrine of eminent domain. Whatever may be your transactions, the private transactions, whether the land rests in one person, whether the land rests in another person, makes no difference. Once the power notification of acquisition of land is published in the newspapers, and once the proceedings have started and the land starts getting acquired, then the disputes you can take the disputes before the appropriate authorities. As to suppose somebody's land is there and somebody he has sold it in favor of another person, but in the revenue record the land is being shown in the name of the previous owner and not in the name of the subsequent purchaser, then even that will not stop the land acquisition proceedings. The defect in title will not come in the way of the land acquisition procedure. Such is the power of eminent domain, and this case exemplifies the same. And this case is or the beneficiary or the person whose land has been acquired entering into an agreement with the authority. Now, the problem with such agreement is that how can an SDM, as subdivisional magistrate, come in the way of a notification and also published in the newspapers that is issued by the state government? How can a state government petty official of the state government like the SDM put at naught the functioning of the entire state government by alienating the land which has been subject of acquisition, by retransferring it to the owner of the land, and then giving the compensation with respect to the rest, and giving land and releasing from acquisition one portion of the land? How is that possible? This is direct contempt of the lawful authority of the government by its own public servant, right? So this is what the case basically highlights. It is just like the Supreme Court passing an order that the trial court has to carry out these tasks. And you'll remember there was a judge in the Calcutta, serving in the Calcutta High Court, Justice Kanan. He was from South India. And Justice Kanan passed an order directing the police not to obey the judgment of the Supreme Court, the directions of the Supreme Court. Then he was called in contempt to the Supreme Court, and of course he resigned. And otherwise he would have been recommended for impeachment for proven incapacity and for proven misconduct, right? So this is one such case. Now, having said that, now let us go through the questions very quickly. First question, everybody has marked correct, therefore I need not waste my time on this. Second question, two kids have marked correct, but one has not marked it correct, so I'll take it up. The state government acquired a large plot of land. I am on 129. To construct a public hospital. The acquisition process followed all procedures. After acquiring the land, the government partnered with the public sector construction agency to start the hospital project. However, before the project began, a private deal Private real estate developer claimed that it had entered into an agreement with the original landowner for developing a residential complex. The developer argued that since the government had not immediately utilized the land, the third party rights created under this agreement should take precedence. Now, this is neither here nor there because eminent domain third party rights don't come in between. If the third party rights had been created, then the best he is entitled to is the compensation which will be granted by the government, nothing more. The reasonable compensation which will be granted either at market rates or otherwise, whichever compensation policy is there of the government, he is entitled only to that. And the private agreements cannot nullify the government's decision to acquire the land. Then in 2020, a private builder purchased a large plot of land from local farmers near a growing suburban area, intending to construct a luxury residential complex. Clearing the land and drafting construction plans. In 22, the state government initiated land acquisition to develop a public park and recreational area in the same locality. During the acquisition process, the government included the plat on land purchased by the builder in the notification, citing public purpose. The builder opposed the acquisition, arguing that the land had already been acquired through private agreements before the government's acquisition process began. The builder also claimed that they had invested considerable resources and the government's acquisition was unjust. So at the most, he is entitled to compensation, nothing more than that. Government acquisition for public purpose overrides private ownership and ensuring larger community interest. At the most, he is entitled to a fair compensation. That's all, right? चलिए आगे. His agreements will not come in the way of government's power exercise of powers under the doctrine of eminent domain. That can't be that can't be preempted by private agreements between the landowners. The judgment is now I come to 131. Here also partly incorrect. The government issued a notification for acquiring agricultural land owned by several farmers to develop a railway terminal. The notification identified the land parcels and announced compensation, who were listed as lawful owners in the official records. However, in the acquisition progress, it was revealed that the land had been privately purchased by a real estate builder in 2019 from the same farmers. The builder had started preliminary groundwork to construct a commercial complex on the land. However, due to delays in updating ownership records, the builder's name was not reflected in government notification, which still listed the farmers as rightful owners. The builder filed a case claiming rightful ownership of land and cancellation. At the most, he is entitled for compensation, nothing more than that. Compensation will be given to the builder, but the power of eminent domain, power exercised under the eminent domain cannot be questioned in this way. At the most, the government, if it cancels the notification subsequently by another notification, then only it is possible. Nobody else can do it. Now we come to 132. This is 100% correct, so I will not take it up. Then 133. The government compulsorily acquired a land parcel to construct a housing project. The housing board entered into an agreement with private real estate, allowing the company to develop the land into a luxury commune. Now, this can be not possible. Once in exercise of eminent domain, you have taken the land for a particular project. You can't divert the land to some private project. That is not possible. In such circumstance, the government has to cancel the acquisition notification and return the land to the farmers whose land was taken. Right. So, vexatious, and then you have yet another paragraph. Yes, 137. This is a paragraph on attempt. What do you mean in law by attempt? So please go through it and tell me what is the paragraph talking about.
So this passage talk about the recent Allahabad High Court ruling, and in which the High Court ruled that the actions like grabbing a minor girl's breasts and breaking her pajama strings and trying to drag her under a culvert, these actions don't qualify as a rape or an attempt to rape. Instead, the court said that these actions were aggravated sexual assault, and in this case, two men, Pavan and Akash, they were initially charged with rape under the POCSO Act, But the High Court said that for an attempt to rape, there must be clear evidence that the accused were determined to commit rape. And the High Court said that it was not proven here. And the court noted that the accused didn't go beyond trying to disrobe the victim. And no one claimed that they tried to rape her. And since there was no evidence of attempted rape, the charges were changed to sexual assault under Section 354, subclause B of the IPC and the POCSO Act. And the irony in this judgment is that the court accepted that two adult men grabbed an 11-year-old girl, broke her pajama string, and tried to drag her away, and they were stopped only by a passenger, and yet this was not legally considered even as a attempt to rape. And the law chose to focus only on what didn't happen rather than what almost did. And we live in a society where we teach children to stay safe, and it's ironic that the law sometimes needs proof of complete harm before acknowledging an attempt to cause it. I personally feel very disappointed by reading this judgment. That's all from my
Yes.
side.
That is why Justice Krishna here said there is nothing wrong with the law, but there is everything wrong with a judge sitting on the bench without a sensitized heart or a sensitized mind. That is what creates a problem. Yes. Yes, Tanishka.
The passage discusses the Allahabad High Court ruling in a case involving accused grabbed a victim's breast and broke her pajama string and attempted to drag her beneath a culvert. But High Court ruled that the allegation did not constitute attempt to rape or penetrative sexual assault. Instead, the charges modified by assault with intent to disrobe and aggravated sexual assault. And there is a criteria for attempt to rape. The prosecutors must prove action beyond preparation and showing the clear determinations to commit rape. And witness statement and evidence did not indicate intent or action lead to rape. And the High Court directed the trial court to issue a fresh summoning order under the revised sections. And there is a accused Pawan and Akash were initially summoned under the POSCO Act for allegedly assaulting a 11-year-old girl. And the how the severity of the crimes assaulting a minor is deeply traumatic manner was downgraded for attempted rape to aggravated sexual assault, despite the victim clear distress and nature of attack.
Yes.
And then and justice is not meant to protect victim yet legal allowed the accused to face lesser charges despite the gravity of
Yes.
their action.
So the Allahabad High Court had ruled that the groping of a minor and attempting to disrobe her does not amount to attempt to rape, but will qualify as aggravated sexual assault. The court had held that if the act is considered to be attempt to rape, it must go beyond this preparation and must show clear determination. Since there was no such evidence of the intent, the accused was rid of the charges of rape, which were under the section, were rid of his original charges, which was section 376 IPC and POSCO Act. The court had instead the accurate trial under section 354 IPC, assault with intent to disrobe, and section 9 of the POSCO Act, which is sexual assault on a child under 12 years. Now, the punishment for these charges when they are convicted amount to around 20 years. 7 for the section 354 of the IPC Act and the section 10 of the POSCO Act, which gives an additional 7 years, 5 to 7 years. So around 14 years.
Yes. So basically, this fact situation, in this fact situation, you know what is the situation. I need not repeat the facts even. What is legally pertinent is when does POCSO apply? And second thing, which is relevant here is what is the distinction between preparation and attempt. This is what is legally relevant here. Rest is all factual narration. Factual narrations don't make up for the legal proposition. Legal proposition is a mix of facts and law. So the difference between preparation and attempt means a preparation is not punishable unless it is specifically made punishable. For example, in some offenses, preparation may also be punishable, but it is specifically made punishable by the law. Otherwise, by default, preparation for any offense is not punishable. But suppose it is terrorist activity, preparation will become punishable under the Terrorist Activities Prevention Act, right? Then there will be preventive detention. There that may follow as a consequence. But then if the BNS or the former IPC makes preparation itself punishable, then it is by way of a specific provision. It is not otherwise. Otherwise, preparation is not punishable. If dacoity, preparation for dacoity is or robbery or all this gangsterism and preparation therefore is made punishable, those are very aggravated offenses where preparation is made punishable. Otherwise, usually preparation for any offense is not punishable. Why it is not punishable? Because preparation is all in the mind. You may be thinking that somebody is preparing for committing a crime, but actually he may be preparing for something else. The same tools, you can do farming with the same tools, or you can carry out an act of assault with the same tools. So you can't really divine the mind of a person and get to know when the preparation is started and when preparation was for the wrong alleged. Therefore, preparation is in the realm of probables, and preparation is not punishable, whereas attempt is punishable. But what distinguishes preparation from an attempt? This is the question that arises. What are the factors we should be looking at in determining whether or not preparation amounts to an attempt? Now, suppose suppose XYZ is setting hut to the fire. Say somebody is hut out of vendetta. He wants to set the hut to the fire. He goes to the market. He fetches a bottle of say kerosene. Suppose he wants to sprinkle the hut with kerosene and then set up a fire. Now he goes to the market. He brings some matchsticks also, right? He brings a can of kerosene also, and then at night he goes there to the site and sits there. And instead of setting the hut to the fire, he starts offering prayers to the God that he should succeed in his aim. Is he still preparing, or has he commenced the attempt? He is still preparing. He has not commenced the attempt. Suppose now he has sprinkled the alcohol or the kerosene that he has brought on the twigs of the hut, or some other material which is highly inflammable here he sprinkles that with the kerosene, and then he starts scratching the fire stick, the matchstick, and a matchstick does not burn because the wind is blowing. He has completed the attempt. Means attempt is the penultimate thing which would have succeeded in its object, but for certain circumstances which were beyond the control of the accused. That is an attempt. Therefore, the question that we have to ask in assessing whether a situation discloses a scenario wherein the phase of preparation is over and the attempt has already started. The law point is that this should have been the last act which he should have performed. And if this was the last act that he could have performed, but for intervention of some outside agency, he was not in a position to perform that last act. And probably what the High Court judge has done is he has been of the impression that still the attempt had not commenced. He was still, the accused was still in the process of committing the attempt. Had he proceeded further, then it could have been attempt. This is probably what went into the mind of the High Court judge. So the distinction between preparation and attempt is highlighted by this passage. Now, having said that, let me take up the questions one after the other. First question, everybody has marked correct, so I will not spend time on it. Second one, yes, this needs some time because everybody seems to have marked it incorrect. In 2023, a man named Arjun was accused of assaulting a woman, Priya, in public park. According to the complaint filed by Priya, Arjun attempted to forcibly remove her scarf and outer garment while threatening her with physical harm. Incident was witnessed by bystanders. Now the distinction between this and the other cases is, just see the facts here. Witnessed by several bystanders who intervened and restrained. During the investigation, Priya stated Arjun's actions were deliberate and intention. Intention was to carry out an assault. The prosecution presses charges for attempt. Decide the prosecution plea. So here, the distinction between preparation and attempt, and preparation and attempt for which kind of offense has he started? Can we say that this is the last or this is the penultimate act which he has done, and beyond this he will start committing assault? Can we say that by looking at these facts? The fact is of disrobing, and the fact is done. The fact is the situation, the incident is taking place in the presence of several people. So can we say that this is the last and this is the penultimate act? This is the penultimate act, and if this act is not prevented, then he would start attempting assault. Can we say that? The answer is no. Because still there are so many acts that have to be committed that are left. Therefore, this is not a case of attempt of assault, but this is a case of attempt to disrobe. I come to the next question, because next question also seems to have been marked incorrect. In 2023, a case was filed against a school janitor, Ramesh, who was accused of sexually assaulting a 15-year-old student. The incident came to light when the child confided in her parents. During the investigation, it was revealed that Ramesh had used his position of trust to isolate the child and commit the offense. The prosecution argued that the act constituted aggravated sexual assault on the 9M. Now, this is a question more of comprehension, because the 9M applies when the prosecutrix is less than 12 years of age. If you have read the fact situation carefully, it won't apply when the kid is of 15 years of age, but the act will apply only when this is the kid is, of a particular age. Otherwise, it won't apply. Right? I need not go to the fact case because it is given there, and I'm sure. Do I need to point it out, or are you already aware? Since you are not objecting, so I presume that you are already aware, and move forward. I come to question number 140 because two kids have marked it correct, but one has marked it incorrect. 2023, a businessman named Ravi was accused of embezzling funds from his company. The complaint filed by his employer alleged that Ravi had diverted significant sums of money from company's account to his personal account. Presented documents in the defense took an objection. Document did not reveal. This is 140. All right. Prosecution presented documents including bank statements and emails. The defense took an objection that document did not indicate Ravi's direct involvement in the embezzlement. However, charges were framed, and the case proceeded to the trial. Ravi intends to challenge the frame of charges, decide whether he has. Yes, this is basically a question which is on other aspect of the fact situation which has been provided to you. The fact situation says that when you are in the direction of framing of charges, then you don't actually decide the case at that stage. Instead of deciding the case at that stage, you are only applying your mind to whether or not there is a plausible case against the accused. If there is a plausible case against the accused, then you don't direct the frame of charges under sections which are different from those contemplated in the FIR. Those directions cannot be given at a preliminary stage of taking cognizance. At the cognizance stage, you just apply your mind whether or not it is possible. For example, somebody, the fact situation discloses that he is accused of murder, and then prima facie it appears that he was not even present at the stage of at the place where the crime was committed. Now, what is the point in proceeding with such kind of trial? That kind of thing is there. Here there are allegations. Here there is an involvement. Here there are certain statements which are being made, and merely because entire documents may not be sufficient. Sufficiency or insufficiency of evidence is not to be seen at this stage of frame of charges. Only a plausible case is made out, a prima facie case is made out or not against the accused. That is the only thing that has to be seen. Now this requires some consideration of the fact situation. So I'll take you to the fact situation where from I am coming. I'll show you in the passage. If you have already been able to put your finger on the particular line or passage in or paragraph, please let me know. Here, near the last few passages, first, second, third from the bottom. The court observed that a prima facie charge of attempt to rape was not made out against the accused, and instead they were liable to be summoned for a minor charge of 354 clause B IPC, that is assault, or abuse a woman with intent to disobeying or compelling her to be naked, and section 9 M of the POCSO Act. Provision states that committing sexual assault on a child below 12 would be aggravated sexual assault. So this was what I was referring to in the earlier case. Thus, the summoning order was modified, and the court in a decision to issue a fresh summoning order. Now, the problem with this is what has been done. Now, what is the law on the point? The law on the point is stated somewhere in the paragraph, and I want to bring your attention to it. Yes, these are the two contentions, out of which the second contention is sound. Challenging the summoning order, the accused moved the High Court, wherein it was primarily argued that no offence under 376 of IPC was committed, even if the complaint version is taken on its face value, and the case does not go beyond the extent of 355, 354, 354B IPC and relevant provisions of the POCSO Act. Now, on the other hand, the counsel for the respondent submitted that at the stage of framing the charge, the trial court is not supposed to meticulously sift and weigh the evidence and material collected during the investigation. At that stage, only a prima facie case is to be found for putting the accused on trial. That is the correct exposition of law. That when you are merely at a preliminary stage framing of charges or issuing a summoning order, then in that case you don't sift through the evidence, you don't weigh the evidence, you don't weigh which side, whether this side has committed the offense, not committed the offense. All you have to see is that whether a prima facie case is made out against the accused. If a prima facie case is made out against the accused, then you don't direct at the preliminary stage itself that you convert the charges which have been framed in this case to a lesser charge rather than an aggravated charge. That kind of thing is not done. This is what is wrong here. And in the case which I was pointing out, now what is happening here is that the prosecution, the incident came to light in 20 business filed complaint alleged that diverting significant sums of money. Prosecution presented documents. However, charges were framed against Ravi. Now, charges were framed against Ravi, and the case proceeded trial. Intends to challenge the frame of charges. Now, this frame of charges can be challenged if you don't have any case. I mean, the prosecution doesn't have any case against the defense, and yet they are proceeding with the case. Then only the charges can be quashed. Otherwise, the charges will not be allowed to be quashed, and the trial will continue. Is that clear to you? All right. Then we have finished 159, and now we can go to the next one, which is 160. Let us take it up tomorrow. It's quite a bit. Today we have finished one paper or half a paper. ठीक है बेटा. See you tomorrow. I just wanted to say one thing.
Thank you, sir.
That you must have seen the, just one second, just hold on for a minute. There you must have seen that universal guide for CLAT. Have you seen that?
Yes, sir.
You must have seen the universal guide. Then there is another guide which is by AP Bhagwaj. So what I want you to do is you kindly go through the constitutional and the basic part in these two books. Either book, both are good. Either one you can take. So whichever book you have, you start reading that. I want you to take the static GK, the GK that does not change. For example, who was the chairman of the Constituent Assembly? Who was the chairman of the drafting committee in the Constituent Assembly? Who was the advisor to the drafting committee? And all these, this is static GK. It does not undergo any change. These are things regarding our polity, our constitution, and there are several other things like that. Well, for example, how many women justices have been there in the Supreme Court? Now, these are things that don't change. How many women presidents of India have been there so far? How many minority communities presidents have been there so far? So these are things that never change. Then if the vice president has to resign, then to who does he tender his resignation? If the president has to resign, to who does he tender his resignation? These are things that never change. These are static in this thing. Particularly the constitutional history, that will not undergo any change. So I want you to do that very well. I will weave that in your current legal portions also, but don't wait for that. Please, that has to be done because that constitutes a part of legal awareness. Club that with your 11th class book of political science, which is Constitution at Work, and this will become a perfect for this exam. This will be good. So that would be sufficient. So how much we have to do? Number one, Pratyogita Darpan. Number second, all the newspapers, at least 4 newspapers, whatever legal part is there in those newspapers and whatever is significant, we have to catch that. We don't have to miss a single article from these newspapers. That is very important. Then what we have to do, all the prominent articles which are coming in various places like First Post, like Supreme Court blog, SEC blog, like Nyay.org, or in other sites, sites. So we have to cover all those. Then English portion, we have to cover a maximum number of high quality short stories, extracts from high quality short stories, right? We have to take them up and we have to complete them. This will be highly useful with other part plus NCRT. That is for the current part. Then for legal reasoning part, we are already doing legal reasoning plus legal affairs knowledge we will derive from either the universal, if you have the universal book with you, or the AP Bhardwaj book. That is also good, but I prefer the universal book. That is very, very comprehensive. Very AP Bhardwaj is also good, but still universal is quite a nice book. I have read both of them, but you can read either one of them. They are both the same. If you have not read AP Bhardwaj, then you read universal. Universal covers the things quite nicely. So that has to be done in legal reasoning. Then you have logical reasoning. For logical reasoning, we have to increase the diversity of passages. I mean, diversity of passages means diversity of sources from which the passage comes. We have to include. Presently, we are focused on newspapers, but we have to be focused on other magazines also that we are in the process of doing. Today itself, I have taken two logical reasoning passages or three logical reasoning passages from EPW. So that I'm already doing. And which else is remaining? Quantitative aptitude tomorrow. Sir will start taking continuous classes. Half an hour class will be devoted. Half an hour, 45 minutes will be devoted to quantitative reasoning on daily basis. So I want you to keep this in mind that constitutional history along with your NCRT book that also has to be done. Just like Patrika Darpan has to be read for the current portion along with the newspapers, right? ठीक है बेटा, don't ignore that. Constantly revise, read. Constantly revise. That is the only way in examinations. ठीक है बेटा, see you tomorrow then.
Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.